Okay, the next case is DIANE PUGH versus James BOWEN and DIANNA BOWEN. Okay, Mr. McGill.
Please the court. I'm Patrick McGill from Orlando on behalf of the appellant DIANE PUGH. I'd like to reserve 5 minutes for rebuttal if need be. I suspect I may not even take the full 15. However, I'd like to boil down the argument, if I may, to two salient points. There is a whole bunch of agreements that were entered into between these parties, all of which were prepared by Mr. Bowen, who is no longer a party to this action, having quitclaimed his interest to Mrs. Bowen. So we're left with just the wives of what used to be two couples negotiating. There's a series of agreements that were reached. It's very confusing.
Let me ask you this. The parties agreed that the December 31st, 1997 agreement superseded the two prior agreements, correct?
We do accept that.
So there's no question about that.
Right.
At trial, your client conceded that her May 2004 payment was more than 30 days late. It was received on June 1st. Is that correct?
She conceded at cross-examination to a terminology and a way of expressing it that was not what she meant. She acknowledged that it was received after the 30 days.
Okay.
But the legal argument was still that it was posted before the 30 days were up. That agreement did not say time was of the essence. That agreement was under a course of conduct between the parties for 7 years.
I thought that agreement had the same termination provision upon a payment being 30 days late as the prior agreement.
The words more than 30 days late are in that agreement.
Okay.
The words.
So why isn't there competent substantial evidence to support the trial court's finding that that agreement was breached and therefore terminated properly?
Because it's a matter of legal interpretation of the contract itself where the court erred. The court made a correct factual finding, which we concede, that the payment was actually received after 30 days had passed. It is also conceded, there's no contrary testimony to the fact that the payment was posted within 30 days. The court ignored the course of conduct between the parties as to...
I thought the course of conduct was that the payments were that was the only late payment.
I don't think that was the testimony or evidence. There wasn't any evidence that it was actually received the whole time. There was evidence that she would post the payment if it was by mail within the 30 days, and that was acceptable conduct.
I thought there was evidence that she was late on occasion or frequently, but never more than 30 days late.
Right.
That's the question of defining late. Under her definition of late, it was posted within the 30 days or delivered within the 30 days. This is the first time that Mr. or Mrs. Bowen called her on it and said, it's late, we're going to terminate the agreement.
Well, let me ask you this. Is there any evidence, because I don't recall any, that there was another payment that was received more than 30 days after the due date?
No, I can't claim that. There was not any evidence one way or the other on it. But there was her testimony, which was uncontradicted, that she had always considered posting it within the 30 days to be acceptable, and there was no calling on it until the May 2000.
But it could have been because it was always received within the 30 days.
Of course, you could interpret it that way. I agree.
My notes on this indicate that there was a missed payment in September, and the check was finally received in October. It was dated October the 8th, but had September written on the memo line.
Yes, sir.
And that was under the June 1st, 2004
That was under the
agreement.
June 2004 agreement. Yes, sir.
Well, why isn't that late? I mean, is that a default then if they don't make that September payment?
Okay, I'm going to concede for you that the June agreement does say time is of the essence. The June agreement does say that it is to be received within 30 days. That's unambiguous. And it was not, in fact, received within 30 days.
As I understand it, you would agree that if the December 31st, 1997 agreement was properly terminated, such that the June 1st agreement was valid, not subject to your defenses, your defense that was induced by fraud and that kind of thing,
yes,
then it was properly terminated upon that excessively late payment.
I'm not willing to go quite as far as the way you said that.
Huh?
Here's why. First of all, I think that she was entitled to rely on the postal system. She did send it in time. There was evidence that it was sent in time. The only evidence that we have was the evidence of Mrs. Bowen, who was not then receiving the payments, to say that she never got the payment. Then there was testimony that was uncontradicted that Mrs. PUGH was told that it had not been received, and she said, "Great, I'll send you a replacement." That's why it's denominated September, the one that was received in October. It was to be a replacement. By then, they had attempted to terminate the agreement. So I think we still take the position that the June 04 contract should not have been accepted by the court, that it was induced improperly, but that I also have to acknowledge is probably...
But would that be fraudulent inducement? Would that really be fraudulent inducement if there's a legitimate argument that the prior contract had been breached? Because it seems like they at least have an argument that the contract was breached.
Well, that's what I was saying.
I can foreclose. And so is a compromise or settlement, now we're going to enter this new agreement that makes clear that time is of the essence. I don't see why that's fraud at all.
I can't in good conscience say that the court did not have the right to make that factual determination based on the testimony that was presented. That is something that the trial court is to do, and it was presented to the court, and the court found otherwise. So I can't look you in the eye and say that the court did not have the right to make that determination. But the court did not completely consider the other argument, and that was a mutual mistake of fact if it was indeed a payment that was made in time because it was posted in time.
But why would that matter under this? Under these circumstances where I'm the property owner, I'm the lessor, and I say, listen, you breached your agreement, the payment's late, I'm going to terminate the agreement and kick you out of the house. But if you want to enter this new agreement that makes clear that time's of the essence, we'll resolve it that way. And you say, no, I really wasn't late. Well, you say that, but I say you were. The facts are what they are. They're subject to interpretation. You could go either way with maybe she was late, maybe she wasn't, maybe it's posted on time, but why would a compromise agreement that makes it clear that time is of the essence be a mutual mistake of fact? Because I'm still saying as a lessor, but I didn't get the payment on time. And that was what they said. That was their position. You breached, I didn't get the payment on time.
Well, our position was that was a mistake, that it was indeed on time. Just because it was received on the first day of the next month does not make it late. And you've also used the word lessor, which leads to our second argument, and that is this was improperly construed as a pure rental agreement. Even if it was a pure rental agreement, there is no evidence, nothing was presented that any 3-day notice and an opportunity cure was ever given. And it's our position that this was from the start. Every agreement talked about purchase, a purchase option. The first agreement even had an amortization schedule, which was presented in evidence. That the entire 7 years of this course of conduct, Ms. PUGH was relying upon the building of equity in that property, and under the law, 69701, and the cases which construe it, that's a mortgage. And it needed to be foreclosed if it was indeed going to be enforced or terminated. The only thing that was given was a notice to vacate, a 15-day notice, which assumed that it was a month-to-month tenancy, and there was never an opportunity to cure, there was never a 3-day notice, there was never a foreclosure or a formal declaration of default that should have been required, and the reason is because of the devastating effect that had on Ms. PUGH, who had, she thought, been building equity in real estate all of this time, and suddenly finds that she doesn't even have an opportunity to find a buyer, to find a financing, to close the transaction, to get somebody to
Let me ask
redeem
you
that
this.
equity.
I could not find where you raised the equity of redemption argument in your initial brief. You want to point me to that?
It was not specifically addressed in the
Okay.
argument or cases. It was addressed both in the introduction and in the conclusion. We did refer to the equity of redemption in both places.
Okay, and I think you're an esteemed appellate lawyer. That's not sufficient to raise an issue for appellate review, correct?
I think it is, because we also have, don't forget, we have the devastating effect. We've argued that those are purchase agreements right along. And we've argued right along that this was an improper way to bring it in an eviction action. We asked the court below to construe the contracts, and we've asked the court up here to reconstrue them because I think the court below improperly did so.
Okay.
And if there are no other questions, I've concluded my argument.
Good morning.
Morning.
Victoria McFadden. I represent Mrs. Bowen in this action. And the court did focus on one area that I brought to the court's attention, which is the fact that equity of redemption was only raised in the appellate brief, in the introduction, and in the conclusion. Equity of redemption was never raised during the entire lawsuit until after the final judgment, when I believe he moved for rehearing, and then he raised the point of equity of redemption. The court in this case, the trial court, was asked to determine occupancy, and in 1995 entered an order requiring the plaintiffs to put the rental payments into the registry of the court. We have maintained all along that this was a rental agreement, not any type of mortgage. The pleadings that the plaintiff filed, he asked the court to enforce the first two agreements, which were the 1997 agreements. And he did talk about the 2004 agreement, but there was absolutely no mention of the December 1999 agreement. It's our contention that the court did not err, that there was competent substantial evidence in this case to confirm that there were a series of agreements that were terminated by the late payments more than 30 days, and the entry of the new agreements.
Can you address the plaintiff's argument that it's a matter of legal interpretation, the definition of what is late in the contract?
Yes. Again, I think in our answer brief, I believe that there was testimony from the plaintiff that her payment was not late in May of 2004. And I believe that I went through her deposition where she did admit that the payment was late because it was received in June. When my client called her and said the payment was late because it was received late, at that point she entered into a new agreement. I guess at that point she could have said no, it wasn't late, and they could have gone through litigation at that point. But instead, what she chose to do was to enter into a new agreement. So again, I believe at court that we brought to the court's attention that the payment was late, and it was more than 30 days late, and automatically terminated by the terms of the agreement, the December 1997 agreement. Does that answer your question?
Yes.
Does anyone else have any questions?
I don't think so.
All right. Thank you.
Thank you very much. Anything else, Mr. McGill?
Two quick points.
Can you address the respondent's argument that it does appear, you talk about today about the June 2004 contract, but it does appear that you in the lower court sought to enforce the June 17, 1997 contract.
That's correct. And what we construed the December agreement to be is a clarification of the original agreement. We took the position that 1997, those three separate writings constituted a contract, and we sought to enforce it. I did realize, and the court heard at the trial, that the complaint and the original attempt to exercise the option referred to the June agreements rather than the December. That was an oversight. We agreed that the December agreement is part of that. But that's kind of the point. We were seeking specific performance right from the start. That's part of the complaint. We asked the court for an opportunity to buy the property under the terms of the agreement. Even if we're operating under the June 2004 agreement, we still did not get the opportunity to close that contract and purchase the property, which we had asked for from the beginning and was denied, and I think that was an error of law. The other quick point in rebuttal that Apolli pointed out, that the court made an order for payments into the registry. Please note that order reserved on how to characterize those as either rental payments or as payments towards the equity of the property. We think the court was in error in how it later construed it, but it was without prejudice. It wasn't a determination at that time that they were rental. And also I'd like to point out that although counsel has referred to two places, once in her deposition and once in her testimony at trial, where Ms. Pugh was willing to agree that it was received late, she clarified that later in each case as to mean that they were received but not necessarily legally late in her eyes. So I want to make that point. It was not a real admission that they were late payments. Thank you very much.
Thank you both.